In this video, we'll discuss the remaining portions of discharge of obligation by termination of the contract from one side, and that is for the third one, lapse of stipulated time. So, once the lapse of stipulated time as 3-year limitation is fixed under Limitation Act 1962. So, as an illustration to this, Ashok gave a loan of rupees 60,000 to Ram but did not collect within the stipulated time mentioned in the agreement, so the obligation terminated as per the laws. So the next one, that is operation of laws. So regarding operation of laws, there are three methods. One is by merger, and the second one by unauthorized alteration, and the third one insolvency. And by operation of law, how a superior right merged within the inferior rights. So, for example, a tenant purchased the property from the owner. So, the very ownership of that property, which is a superior right with the owner, instantly merged with the inferior rights of the tenant, and by unauthorized alteration, which is a kind of material alteration without the knowledge and consent of the party. So a shopkeeper took a loan of 10,000 from the Axis Bank at the interest of 2%. But the bank, without the knowledge and consent of the shopkeeper, increased it at to 5%. So this is a kind of unauthorized alteration by which there is a termination of obligation. And the third one, that is insolvency. So once a party declared insolvent, for instance, an hotel owner took a loan before paying back the whole debt, declared insolvent by the court. So here there is, by operation law, the obligation is terminated. And now we'll go to the fifth one, that is under section 39, breach of contract, and show how a contract is terminated. So breach of contract without valid or lawful reason repudiated. So for the very illustration relating to this, Food Corporation of India took the order of supplying wheat to the trader on or before 30th January, but it refused on the same day. So this is a kind of breach of contract, and that breach of contract is of two types. One is actual breach, and the second one is anticipatory breach or constructive breach. So actual breach for instance, are shall an horse to be, but refuse on the very day of selling the horse, so it is a kind of actual breach. So, as an illustration, a theatre sold tickets of a musical show, but on the day of performance announced the very suspension of the musical show. So, this is a kind of actual breach. And now we'll go to anticipatory breach or constructive breach. So, for instance, if it would be announced some days before the day of performance, it would be considered as anticipatory breach or constructive breach. So, then it would be anticipatory breach. So, if the very termination of the contract or the obligation is announced before or some few days before the day of actual performance of the contract, then it is considered as anticipatory breach. So, the very effects of anticipatory breach are right to sue and wait for the performance and then go to sue. So, the very effective that in case of any breach of a contract, the party has the legal right to sue the other party who defaulted in the contract, and secondly, the party can wait for the performance of the contract, and if it is not performed in due time, then he has the legal right to go to the court to sue the party who is at default.